Rent. I lead on our marginalised private renters work, and in particular minority ethnic and migrant private renters. We are joined today by Sam Lister from the Chartered Institute of Housing, who will be giving an excellent presentation on all the things that are really sort of you should have in your toolkit, specifically as someone who is a migrant or who supports migrants. So without further ado, we'll kick off with the presentation. I can stop sharing my screen.
Okay.
Probably. I stopped sharing? No, I haven't. There we go. There we go.
Right. I need to share mine now. I'll just to introduce myself a little bit more first before I kick off. So, as Teddy said, I'm Sam Lister from the Chartered Institute of Housing. We're a professional body for people who work in housing, and I work in the policy team. And I've been involved in the policy issues around private renting and benefits and migrants' rights as well for far too long, really. But there we go. And you'll see this when I get into the presentation. We've produced a resource for migrant renters about housing rights and your rights to access to housing, and I'll touch on that. It's on the website. It's a free resource. It's split into two halves. So there's a side for people, service users themselves, and there's a side for administrators, for councils and other people and DWP who are making these decisions. We found quite a long time ago that there was a lot of misunderstanding about what the rules were, and they weren't being interpreted correctly. So this was to, give people more confidence that they about what their rights were, so they could assert them, and also to help local authorities, kind of make better decisions as well. So get it right in hopefully 90% of the cases. Okay, so I'm going to share my screen now, and hopefully the slide should come up.
I'll just quickly put a disclosure I should have before introducing. Sorry, Sam. This session is being recorded, and it is being streamed to YouTube, just so people are aware. But everyone's questions and answers are anonymous. Comments on the chat are anonymous. There we go. So please don't worry about that. Anyway, sorry, Sam, take it away.
Yeah. So housing rights for migrants. Tilly opened up by saying I'm going to cover renters' rights. What I'm not going to cover is all the stuff around your rights as a tenant and that kind of stuff. I'm sure there are plenty of other generation rent resources around that and webinars around that as well. So I'm not going to be covering things, like what rent you pay, whether you can challenge it, what happens if you've got disrepair. Quite happy to deal with some of those in questions afterwards as well. The resource I talked about also deals with those issues. It's got a private rented section on it as well. But I'm going to be talking about access to housing. So that's access to private renting. And it's also about access to homelessness and benefit services should you ever need them as well. So help with rent, that is, through benefits. Right, let's try and move this on. Yeah, okay. So this is the website I was talking about. It's called there's the web address there. It's called housingrights.info, and you can go in there, and there's the two halves. You can click on the buttons, and then it will take you through what your rights are according to your status. And I'm going to be talking about status of for most of the presentation, because that largely determines what rights you've got.
Is it possible,
Okay,
Sam, to
yeah,
open up present mode? Sorry, on the slideshow. We've just had some feedback that some people are struggling to see.
sorry.
Is it possible to go on to present mode
Oh yeah, yeah.
on the
Sorry,
PowerPoint?
yeah, yeah. Okay,
There you go.
that's
Perfect.
better.
Thank you.
I'm just now, and let me just see if I can. Oh yeah, I didn't realise my slides had done that, but there we go. Right, okay. So nearly all of the rights that I'm talking about, so access to private renting in England, homelessness should you need it, and benefits to help pay your rent, depend on your access is around defined in terms of whether or not you're subject to immigration control. And just be aware there are kind of three different ways of defining immigration control. There's the actual real one, which is the most important one, which determines whether you can actually be here or not, and that's in the Immigration Act of 1971, and that's basically the means by which entry, right to live in the UK, right to settle, is regulated. As you know, you have to apply for leave to come here, and and what sort of leave you get depends on what you're applying to come here to do. So whether it's to work, to settle, perhaps with a UK partner or something like that, or to study. And then there are the rights and access to housing use immigration control as a means to either blocking or giving you access, but they use slightly different definitions for each. So you can't assume that just say, for example, you've got access to one of these, then your immigration status is necessarily safe. So yeah, the definitions are slightly different. So the proper definition is, yeah, that you require somebody who's subject to immigration control is somebody who requires permission to enter. Permission is called leave, to enter, live, or settle in the UK, and there are only two groups of people who that doesn't apply to, in terms of people who are British or not. And then the homelessness, anybody who requires leave to enter is defined as subject to immigration control and therefore blocked. And benefits uses a slightly lesser threshold. So that's anybody who requires leave who doesn't have it, or who has leave with a no public funds condition. So, you know, some people that implies obviously that some people with leave have access to benefits, whereas they might not otherwise. Okay, so what's leave? Leave is granted by immigration officers. So I'm assuming that some of you, most of you, because you're here, you'll have had some experience of this. So it's granted by immigration officers according to the immigration rules. That's just a set of rules by which they have to make their decisions. It's basically a type of law, and there are different categories of leave, but basically three kinds of different things that may impinge on your status as to rent or to access housing services. So leave can be open-ended, and that's called indefinite leave. So there's no time limit on it. So if you're settled, then you'll have indefinite leave. Or it can be for a fixed period, and often that's 30 months. So people who are coming here to settle, perhaps they're marrying a UK partner, they'll be given 2 blocks of 30 months, and they have to apply after the end of each or towards the end of each and get a new block. And then leave can be with or without conditions. So indefinite leave doesn't normally have conditions with it, but it can do. And then fixed leave, limited leave for a time period usually does, and that normally includes a no public funds condition. And some people can be granted leave, but only on where they've got an undertaking from a sponsor. A sponsor is basically a guarantor that they will, and the guarantor says that they will accommodate and provide for their maintenance if they're without funds at all. So indefinite leave to remain, that's when you can then you've got permission to be here without any conditions, and that's also sometimes called settled status. And any right to some of these rights to housing or benefits may require a change in your status. So people from Hong Kong, British nationals from Hong Kong, for example, get leave with a no public funds condition. If you wanted to access benefits, then you'd need to change your status. You do that before you apply for your services, and always do that with a regulated advisor. So that's the Office of Immigration Services Commissioner, and you can click on that link there, and that will tell you any advisors near you, what level they're at. It's different levels depending on how complex your case is, and whether it's free or not, or whether you need to pay fees for it. So who does it affect? Immigration control. So the two people who aren't subject to immigration control are British citizens, not surprisingly, and certain Commonwealth citizens who arrived here before 1973. They have what's called the right of abode, which just means they're basically free from immigration control. Some of those Commonwealth citizens that are here had problems. You'll have probably heard of the Windrush scandal. That's because you didn't need documentation. You only needed your passport before then. And they hadn't got any kind of proof at all that they, even though that was their status, they couldn't prove it. And that's where that scandal came from. Everyone else requires, any other kind of foreign national needs leave, permission to enter or remain. And the only exception for that is Irish citizens, who get automatically given leave. They don't have to apply for leave. It's just assumed that they get it, except in very extreme cases. Okay, so you've kind of got this hierarchy of status where at the top, you've got unrestricted access to services, and then going down, generally speaking, so if you've got anything down to 7, so that's leave with access to public funds, then you're going to be able to access the rights that I'm talking about. But that doesn't mean that you won't have problems. So there are problems around proof and documentation. So as I said, just a few seconds ago, Commonwealth citizens with the right of abode that had problems with actually proving their status. And even if you're free from some of this stuff, you still might need to prove where you're from, which is where you'll encounter the controls and the questions and the requests for documents, that kind of stuff. And then it's 8, 9, and 10. So the people who don't have leave when they arrive here. Temporary admission, that's where people have been given permission to apply for leave, but they don't have leave whilst they're here. So they're just technically not breaking the law. Okay, so and then there's access to services. This kind of works the other way round. So the ones at the top there, you need kind of the higher level of status in order to access. And as you go down, you don't necessarily need a higher status to get those. So if you're getting homelessness assistance, then you'll be able to apply for the other things as well. Don't worry about the other ones. They're kind of technical. There are some people who are caught in the immigration system who don't have access to funds, but might have access to other services. Yeah, so the one I'm going to talk about most is the private rented tenancy and the right to rent. And this applies in England. It doesn't apply in Scotland and Wales. So this is your rights to rent. So what's the right to rent? It's part of this, what the Home Office used to call the hostile environment, and have now rebranded the compliant environment because it sounds nicer. It's actually the same thing. And the idea of that is to deprive undocumented migrants access to essential services. So yeah, to try and force them to leave or to make life uncomfortable for them. So that includes access to things like a bank account, a driving license, renting a home, NHS services and welfare benefits. So it becomes very difficult to live here without having your immigration status sorted out. And who does this apply to? So these are landlords have become part of the policing system for the Home Office. So anybody who lets property or who takes people in on a subletting basis, so that would include tenants or people accepting lodgers, has a responsibility to do the checks essentially for the Home Office and prove that they've done that. And if they haven't, and it turns out that the person there doesn't have the correct status to be able to rent, then the consequences fall on the landlord as well as the tenant. So it's document checks on prospective tenants and occupiers, and repeat checks on occupiers whose rights are time limited. So if you've been given limited leave, for example, say you've been given 2.5 years leave, then the landlord is expected to do a repeat check. So they on the initial check, they should find out when your leave expires and then do a further check before it does so. Yeah, landlords have failed to comply at risk of civil and criminal penalties. And it applies to all the adults, including those who are liable to actually pay the rent, but also anybody else living in the property and anybody else who's not named in the aggrievement, but could live there by permission of the tenant. The landlord has a defence if they made reasonable inquiries about the occupiers who might be living there beforehand when they did their initial checks. So how does it work? Before moving in, the landlord must check everyone who's a prospective tenant or going to occupy. So that might be, kind of spouse or other family members of people aged 18 or over, and make copies of the documents or ask for proof. Now it's mainly using the online checking service, and the landlord should ask for proof of age if they suspect that so if the tenant tries to get around and say, well, they're only 16 or whatever, so you don't need to check them, the landlord should still ask for proof. Okay, so these apply where you have a time limited right to rent. So your right to rent is basically your leave, the permission that you've been given, and so a time limited right to rent is one that's, where you've got a leave for a fixed period. If you've got indefinite leave, then you've got an open-ended right to rent, but of course the landlord still needs to check that, and they need to check it before 28 days before your the eligibility period applies. So they have to do this once every year, or if your leave is coming up as well, they need to do it then again for that. I'm aware there'll be people from different kind of migrant groups, so EUSS, so the EU settlement scheme. So these are people who entered the UK whilst it was still in the European Union, and applied to stay here afterwards through the settlement scheme. They don't get actually any physical documentation to prove that, but they can prove that through the online service, so that they'll be given, those who applied to stay here will be given either EU settled status or EU pre-settled status. So EU settled status is just the same as the same immigration status as ordinary settled status, so it's indefinite leave. And the landlord can ask to view the tenant's right to rent. So one way the tenant can do that is get a share code through the through the website, and that's the simplest way of doing that. I think now most physical document checks have gone out, and you have to do that through the landlord. The landlord has to do that through the checking service themselves. So when these rules were first brought in, the landlord could look at the documents, take photocopies. Of course, Home Office, being paranoid, were worried about forged documents and that kind of stuff. So that most of it has to be done through the Home Office service themselves now, who check the documents, or you can do it through the right to rent share codes. Okay, so allocations and homelessness. So you must be not subject to immigration control, and that means anybody who requires leave, so that's pretty much any foreign national, doesn't get access to homelessness service unless they're in a prescribed class. So it rules everybody out, and then creates a set of rules which specify which people can still apply. So that's what those prescribed classes are, and I'll go over some of those. And you must also be habitually resident, and this rule actually applies to everybody, also applies to British citizens. So you need to show that this is the place where you've made your home. And the reason that applies to everybody is because, people can get British citizenship even if they've not lived here their lives. So, for example, typically through their parents. So their parents might have emigrated, but they can get British citizenship by descent. They couldn't just arrive then in the country, not having lived here at all later on, and then claim services. So that's what that rule does, and that applies to everybody. So I haven't done all of these, but these are some of the eligible classes. So these are the people who are written back in, and even though they're subject to immigration control, have access to services. The ones that this group is most likely to be in are people with indefinite leave, provided you're not sponsored immigrant and you're habitually resident. People from Hong Kong, who've applied and had their public funds status lifted, and then various other people from Ukraine as well, who's now a very big group, and people who are EU nationals, they actually fall under number 3. So if they've got indefinite leave, and any other kind, or so if they've got EU settled status, or if they've got pre-settled status, they're exempt from these rules. But you'll still have to show you're habitually resident. How does this work then if you're a mixed household? So some of you, you might have married somebody who's British, for example. So you've got leave, they're British, so they don't need it and they're okay. Become homeless. What then happens is, if you're an ineligible person, then the homelessness checks and rights to accommodation are done on the basis as if you weren't there. So, for example, in deciding whether you've got priority need as a homeless person, priority need is given to mainly to households with children. If all of those children are people who are subject to immigration control, then they'll accept the British person as the applicant and say, yeah, you can apply, but you won't get priority need, because that's only on the basis of the ineligible people. So it gets quite complicated, but that's all on the website about when you've got mixed families as well, so you can go through that. And then universal credit and housing benefit. So universal credit is the main benefit now for people of working age. You must not be subject to immigration control. And that, again, as I said at the start, that means that's defined in a slightly different way. So that basically means anybody who has got leave with a no public funds condition attached, you'll be excluded. If you've got leave and it hasn't got a no public funds condition, then you're okay. You've got access, provided you're not a sponsored migrant, and you'll have to be habitually resident on the facts. So that's just means you've made your home here, and some people are exempt from that, because we've decided to, kind of give special status for those. So Ukrainians, for example, who've fled the war, on arriving here immediately, they'd be able to access homelessness services if they did need it. So that's obviously that's a policy decision decided by government, and they made the rules around that. And EU nationals are who have pre-settled status, and who are in paid work, are also exempt from that test as well. So they're basically the people who are EU nationals who arrived here before 2021 but haven't lived here for 5 years yet. Okay, and then you have rules around benefits, a bit like kind of with mixed households. So it depends on who the claimant is. You have to be very careful with these and get advice beforehand. In universal credit, if a couple makes a claim, and you make a claim jointly, usually, and you've got one British and one non-British person, then that would be the British person can make a claim, but they'll only be assessed on they'll be awarded benefit on the basis that they're single. I wouldn't advise anybody to do that anyway. Get your immigration advice first before you do that, because it may affect when you come to renew your status, it may then affect that. And with housing benefit, there's only one claimant. So whoever it is, the British person could claim for both, but that claim, including the other person, would count as public funds, and therefore you'd be in breach of your conditions. So again, don't do that without getting advice, immigration advice beforehand. The local authority who administer housing benefit don't have to, but they could report that to the Home Office, and obviously you don't want that happening. Okay. Don't know why I did that. It was a bit odd. Right. So a little bit more about habitual residence. Generally, this only disqualifies you for a short period. So it's just to establish that this is where you've made your home. And there are various things that, kind of prove that. The disqualification period lies somewhere between 1 and 3 months. So it's not that long. If you go away and then come back again, then you may have to go through a new qualifying period. That doesn't count for things like holidays. Obviously, you're still resident here. If you go on holiday and you come back, but in any other case, if you go back abroad and work there, for example, and then come back to the UK, you may then have to establish habitual residence before you qualify. Okay, that's it. There was an awful lot in there, and I'm sorry, some of it's necessarily complicated, but that goes with the rights. So I'll stop there, and I guess you've been watching questions as they come in, have you, Tilly? Or
Yes. So we've had a couple of questions through. So if anyone has any questions now, then obviously please do use the Q&A function, and we'll be able to get to them. But the first question is there any difference in terms of housing rights and benefit entitlements between those people who have EU pre-settled status and those who have EU settled status? Is the first question.
Yeah, there is. So people who have EU settled status, that's EU settled status is just a form of indefinite leave to remain. So basically, you've got full access, provided you can show that you're habitually resident. And normally, if you haven't been out the country at all, then that's just straightforward. You can prove that on the facts that this is where you are. Pre-settled status is a form of limited leave. So it's just like anybody else now, if they came through the ordinary immigration system, say if they came here to work, they'd be given a period of limited leave. But those who've got pre-settled status are given given greater access. They basically just have to prove if you're in work or self-employment, then you're going to be okay. You'll still have full access. If you're out of work, that's when it starts getting really complicated, because it will depend on what your rights would have been under the system before we left the EU. And there were various different rights for people who were based on the free movement rights. So, depending on whether you were a student, and there was lots of complicated case law around people who are not working but bringing up children, or their children were in school. So it starts getting very complicated. But that only applies if you're not in work. So basically, most people on pre-settled status have got almost full access. It just boils down to whether you're working at all or not. And all of those complicated EU rights are explained on the website, so you can go in. So there's there's a little tab which goes into, you can go into if you're an EEA worker, a European worker, and it tells you all the case law around whether you're a worker at all or not. So, if you're in low paid work or something like that, or only part time, whether you would qualify. And then if you're not in work, whether you had some other right that would cover you, that covers you. But basically, all of those rights are based on the pre-Brexit system. So what the law was before we left.
Brilliant, thank you. Another question. It said, what if I have no fixed abode, what if you have no fixed abode and you can't prove your habitual residence based on property records? What do you do then?
Well, yeah, that's a good question. It's not dependent on you having a tenancy at all. It's basically where you've made your life. So I'm wondering if I can just go, but yeah. So these are the things that in the guidance on the main factors. So there's various sorts of things which you can use to establish that this is where you've made your home. So that'll depend on the length and continuity of your residence. So just the fact, if you can show how long you've been here and that you've essentially settled here, then that will go towards that. Your reasons for coming to the UK, so that will establish things like, kind of whether you've got family ties here, or whether it was for work, your future intentions. So, kind of, it will be different from somebody, let's say, who's come back here but had left and burnt all their bridges. So, for example, if you left to work somewhere else and sold everything off and then come back here, sold all your, all your possessions off you, and took it all abroad, that would be different from somebody else. Your centre of interest, so that's around that's around establishing where you're, basically where you've built your life. So the guidance says things like if you're members of clubs, like, or a gym, where all your friends are, anything else that you can establish. So it can be proven even if you've got not had a tenancy recently, but obviously it becomes more difficult, and you may well be asked more questions around that. There is a page on the website as well on habitual residence which talks about the case law and some of these factors and so that's a piece of case law there about the 1 to 3 months, and that goes through all the complicated exemptions for EU people as well, and various other stuff. But that's one of the, I think, looking at the metrics on the website, that's one of the most common questions that comes up, people being disqualified through that, even though having, nominally having a status that would otherwise qualify them.
Brilliant, thank you. Another question. Can you refuse to participate in online right to rent checks and ask to submit physically instead?
Can you say that again?
Can you refuse to participate in online right to rent checks and ask to submit physically instead? I'm not sure the details on this, but
I think that now depends on where you're from. So I think there's a list of countries at the moment. We're currently going through updating the website on this, but there's a list of countries that have to use the online checking service, and you can't then you can't effectively refuse to cooperate with that. That's the only way that you can establish your right to rent. So those are the ones it definitely applies to, are the EUs, because they don't have any physical documentation anyway. Even though obviously you'll have a passport or a residence card, you still have to go through the online checks, and most of the English-speaking Commonwealth countries, so the Anglophone countries, so like Australia, New Zealand, USA, and a few other countries who are allowed to, if you're allowed to enter through the passport gates automatically, so you can just put your passport on and go through the checks when you enter that way, then you have to go through the online service. And I think government is moving towards, eventually, it may even happen sometime this year, I think they want to do it, is to move to completely away from physical documents. So there may come a point in the future when everybody has to go through the online checks, unfortunately. But again, it's a way of clamping down even more, and to just kind of making it more difficult for people to evade this.
That's good to say. I didn't know about that. We're all learning something today. That's good. So another question. What can I do to help a potential landlord complete a right to rent check? Is there any tips or tricks to ensuring that makes the process easier?
Well, there is, I think. Oh, I'm just seeing. I think on one of my slides. Oh, yeah, there we go. Right. So there's various pieces of guidance. So you see down here, this guidance here will tell you whether you need whether you can get away with a physical check, and there's a guide for landlords about the document checking service. So there are various ways you can do it. Landlords can actually employ an agent to do the checks for them, and if they do, the agent is liable for any mistakes at all. So understandably, some landlords may want to kind of, this is just too much for us to worry about, and they can employ an agent to do that. But then the agent becomes liable, so they will be asking, if you're a migrant tenant, the agent, whoever their nominated agent is, will be doing those checks. So I think some letting agents may specialize in that. I'm not sure, but in other cases, it might be that the landlord is employing as their agent a solicitor or somebody like that who's got the qualifications to make sure that they do these things correctly. So there's quite a lot of guidance out there for landlords to kind of click on those links there. I don't know, Tilly, whether people will be getting the slides at all, or
yes, we'll make sure to send the slides and links.
So you should then be able to click on through all the links on the slide straight through to those websites instead of having to search for them. There is guidance as well, for what it's worth, about preventing discrimination. But obviously, it's very easy for a landlord to kind of get around that by just accepting another tenant, and then there's probably very little that you can do. So there is guidance about, so landlords still are meant not to discriminate, although obviously, and this is the point that we made before the legislation came in, this is kind of pushing them to discriminate anyway, because you still have to, you've got to do some checks, and it's fairly obvious that that landlords are going to be more wary of people who have got white skin than other people, if they in terms of thinking that they might be a risk. So I'm aware that there are landlords who don't do these checks, but obviously they're putting their at risk their liability. So you may come across landlords, kind of who you find normally through face-to-face contacts, who will let to you, but that doesn't let the landlord off the hook. So it's really up to the kind of the individual landlord as to what they do. So the responsibility is put on them, and the fines are quite heavy. So and they escalate with each repeat offence or repeat breach.
Someone has asked, I think this is a more general question about right to rent, that I'm happy to sort of give a generation rent view on, but obviously Sam, if you have a view then from the CIH, then obviously it'd be good to hear. But they said, how can we challenge the right to rent policy? Was it not deemed incompatible with human rights law?
It probably there are probably various bits of it that might be incompatible with human rights law, although because it was done in a statute, then that means so primary legislation, government acts can't be overturned even if they are actually incompatible with human rights law. Secondary legislation can be. So where the government makes regulations which derive from a parent act, then those can be challenged. So you have, that there might be very specific challenges that come up. I'm not aware of any so far, but actually challenging the act itself, even if I think I'm right in saying you could go to court and get a declaration from the court that it's incompatible, but that still wouldn't strike it down. So there might be challenges here and there, but they would be around whether the regulations are compatible with human rights, given the power and the scope that the minister's been given to make them. So that's where the challenges would lie. But that doesn't mean that we don't think it's as a body we think that's awful. Obviously it is, but that's just how the law works, I'm afraid. So you would have to get the whole thing struck down because it's in statute.
I do believe, and I don't know the exact details of this because I'm not a legal person, but I know that JCWI, which is the Joint Council for the
Welfare of Immigrants,
were they did have some sort of legal challenge with the European Court, the European Human Rights Court, I believe, but it was it wasn't accepted basically as they didn't take it up as a case. Basically, I think it was sort of it didn't quite reach that point. So I don't know if that's what the case the person asking the question is alluding to, but the right to rent is still very much in law and still required, unfortunately, from our perspective. And I will sort of finish off the I will go into this in more detail at the end, but obviously generation rent it is a massive issue for us, and we are campaigning against it along with a number of organisations. But I can talk about that a bit later.
Yeah, I just to say, if you want to avoid the right to rent altogether, go and live in Scotland and Wales. You won't get that hassle because it hasn't been brought in there yet. The UK government has retained it as a right to be able to legislate there. So it's a reserved Westminster function. They just haven't implemented it in Scotland and Wales yet. Partly, I think, because it will cause up a stink with the devolved administrations who would almost certainly protest very hard against it, and they might get kicked back. So I don't think that's going to happen anytime. Certainly not before the election, and then probably not afterwards as well, hopefully. But yeah, so that's the way to if you want to avoid the right to rent. I know that's not necessarily a practical thing for people, but yes, it doesn't apply in Scotland and Wales yet. So there is one way to escape it, at least.
Mm-hmm. So we've got 5 more minutes, and there are 2 questions still going, so they might be our final 2. Yeah. So someone else, in case of no fault eviction, section 21, if the tenant stays after the notice period, the landlord has given the tenant, is there a risk of a CCJ, which is a county court judgment? And if yes, how does that impact the tenant's right to live and rent in England?
Well, the facts of the case will be decided by the court, and that won't affect your right to rent at all, and it doesn't affect it shouldn't affect the fact that you've got a county court judgment shouldn't affect it shouldn't affect your right to rent at all. It's possible, and this is the risk, and you may, if you're a migrant, you may well have no doubt have seen some of the questions on the when you apply for your leave. There are rules around basically your fitness to be to live here, that you're an upstanding citizen. Now, staying on after a tenancy has expired really shouldn't affect that, but there is a risk that any kind of county court judgment may affect that. I think, I'm not an immigration expert myself, so that would need an immigration lawyer, but generally try and avoid anything that could be seen as a black mark. Certainly it's not a criminal offence, so I would guess almost certainly it shouldn't affect when you come to apply for leave again, that either. But generally, if you can avoid any of that kind of thing, then do try and stay clear of it if you can. But it shouldn't, because it's not a criminal offence. You would probably need if that did ever pop up when you reapplied for your leave, then you need a good immigration lawyer who would probably be able to deal with that. So generally speaking, it's only criminal offences, but even some quite minor ones now are affecting people, not necessarily when they apply for leave, but if you later decide you want to be upgrade to British citizen, it might then affect your right to do that. So you wouldn't necessarily lose your leave, but it might stop you from they might refuse you as a British citizen. That's criminal offences, not civil wrongs, generally speaking.
I think I'm right in saying that county court judgments only are only enforced when there's been a no payment of rent as well. So it isn't just generally Section 21. No.
Yes.
Yeah.
Yeah.
So if it's just a general Section 21, there's no issues with the rent payment, then there wouldn't be any sort of county court judgment necessarily associated with that, even if they do, even if you are evicted through the courts. County court judgments are strictly non-payment of rent and similar things, but that's
that's
what they're related to.
Yeah.
Okay, final question. Does a change of immigration status, like for instance from pre-settled to settled, require a person to reapply for benefits and or potentially lose those benefits because of bureaucracy?
No. If you're going from pre-settled to settled, then that shouldn't change at all, because the you're eligible if you're settled anyway, and presumably if you're on benefit already, you would have been, you satisfied the rules for pre-settled status, so you don't need to notify that, because it's not something that would affect your eligibility. If you're in a different situation, if your status changed from leave with access to public funds to leave without access to public funds, then obviously that would. So and you might get situations where you can't apply at the moment, but you can apply later. So if you say a British national, overseas national from Hong Kong, they're normally given leave without public funds access, but they can apply to the Home Office to have that no public funds bar lifted. Always do that through an registered immigration lawyer, even if you're just thinking about it, because they will take you through the pros and cons of doing that. Because there's always a risk that you might your leave might not be renewed at some later date. So you always need to get those kinds of things checked. So it depends. If you're going from a status that would disqualify you for benefit, obviously you need to notify that. If you're going from one status to another status that are both entitled to benefits, then you wouldn't need to report that as a change. Just only if you're asked to, provide new documents again, which you might be asked kind of periodically, and then you could just apply, show the new documentation for that.
Brilliant, thank you, Sam. Well, that's all of our questions. I'll just share the final slide on our webinar, and then it'll be good to go. All right. So thank you so much, everyone, for listening to this webinar. I really hope it was helpful. I'm also hopeful that we'll be able to stay in touch, specifically on all things to do with migrant private renters. There are 5 ways here that you can stay involved or get more involved in Generation Rent's work. You can sign up for our emails, which I think most people probably already do, which is why you know about this webinar. But if you haven't, there is a sign up link. There is also an opportunity to share your experience via our website, which is on the link here. All of this, I'll be sharing these links around, hopefully tomorrow. It should be tomorrow. So don't worry about memorizing all the URLs. If you're interested in getting even more involved, we have a dedicated renters panel for private renters. This is where you can help with our research, and the brain of Generation Rent in many ways. So it really helps us keep on track and informed on what we're doing. So by all means, join there. And we also have a volunteering opportunity if you're not a private renter, or if you're just a private renter who wants to take up some volunteering, then that is an option for you. And there are also our social media if you're that way inclined. With our Twitter or X is on the bottom, as well as our Facebook and Instagram. Sam, yes, you have your hand up.
Yes, yeah, I promised our people I'd get a plug in for us. So In terms of I mentioned the housing rights info website. On there, you can sign up to join to get our quarterly newsletter for migrants, all things about migrants' rights and housing. The new copy of that is either, I think it's out next week, so a brand new issue of that. So you can click on the link as you enter the website. You can see a link to newsletter, and we've got all our past issues laid out, and there's a new one coming up. We're always looking for stories, particularly people who've got lived experience. So if anybody thinks they might, want to write about their experiences as a migrant getting access to housing, we'd be, want to do an article for us, then please get in touch, and we can have a chat about that. So you might get into the newsletter if you want to, and you can sign up for the newsletter and you'll get alerts just like you do with Generation Rent. It'll tell you when your next newsletter is coming along, and obviously if it will that will also include summaries of any changes that we've made on the website. So if rights change to particular groups or where we've done an update, that will be there as well. Thank you.
Amazing, thank you. And I'll be sure to share the newsletter stuff around on the follow-up email with the presentation as well. So
Thank you.
A brilliant opportunity for people. Yeah, so there you go. Plenty of ways to get more involved if you are interested in doing so. I also wanted to add that Generation Rent, we are campaigning against things like right to rent and other aspects of the hostile environment policy. I know it's a different name now, but anyway, that are affecting migrants' abilities to access safe housing. So if you are interested in supporting us on that, we greatly appreciate it. If you could drop us either general email or email to me specifically, which is unhelpfully not on the screen right now, but it is tilly@generationrent.org. But if you send an email to the general one, which is there, then that will get its way back through to me. Yeah, so thank you so much everyone for coming. Thank you to Sam for being a brilliant speaker for us. He's done this completely free, giving up his evening. So brilliant. Thank you so much for that. And I will leave you all to your evenings.